then that brings us to the current dispute. So this complaint was filed in early 2024. And basically what happened was Singer started putting out a modified Porsche that they called a DLS or a DLS Turbo, which used a Porsche 911 as a starting point, but Porsche alleges that it's so drastically deconstructed and modified that the car was simply no longer a Porsche vehicle, and therefore breach of contract. You've breached our settlement agreement that we entered into in 2012.
Got that.
But also these intellectual property claims for trademark infringement, trade dress infringement, which is the other issue I wanted to talk about, because I'm not sure we've talked about that before.
What does that mean?
And dilution and some other state law claims. And essentially trade dress is the overall look and feel of product packaging or product design. And trade dress is protected just the same as trademarks. You can get a trademark registration for trade dress. And also that analysis in terms of are you infringing or are you not infringing is the same. It's that consumer confusion. So they brought trade dress claims for the overall look and feel of that Porsche 911 body, and trademark for obviously the Porsche emblem, the Porsche name that was still being used on this DLS Singer model, and dilution. And I don't know if we've talked about dilution, but dilution is essentially an additional claim under the Trademark Act where basically for infringement where your mark is famous. And Porsche, I think we can probably all agree, is a nationally recognized famous worldwide mark. And so that was another one of their claims.
So let me ask you a question about Singer. So this idea of, would it have made a difference if Singer had sort of unbadged or like taken the Porsche marks off the cars before they resold them?
Yeah, I mean, that's kind of the whole point, right? So Porsche was upset because yes, you can do what you're doing, but if you're going to make something so radically different, that material difference exception under for sale doctrine, then you may not use our trademarks. That then rises to the level of trademark infringement. So you can't use the Porsche name, you can't use the Porsche emblem, anything. I think basically if you remove all trademarks from the redesigned vehicle, that would presumably be okay, make Porsche happy. Now, of course, you still have the trade dress issue.
Yeah.
So it could be that Porsche would say, no, that's not enough. You just have to stop making these.
Yeah, it's a very distinctive. It's a very distinctive shape.
Which is why they've got the trade dress protection. So it raises a lot of interesting issues. It's certainly a fun topic. Not much else to say about the case because it very quickly settled. Thanks for listening.
Thanks for sharing that.